Subscribe to our YouTube channel and press the bell icon to get the latest updates.
The government is gearing up for the monsoon session of the parliament in September, and what can be expected on its agenda are bills on almost a dozen ordinances passed by it. So we began KYC on Know Your Constitution this week with an explainer on what an ordinance is and about the President and Governor's powers to make such ordinances. Article 123 of the Constitution talks about ordinances, and in simple words, an ordinance has the same effect as any other law. The only difference is that it is not enacted by the Parliament like other bills after scrutiny in both the houses. Instead, an ordinance is essentially promulgated by the President when the Lok Sabha or the Rajya Sabha is not in session, and so it is not possible to pass laws through the usual route. Article 123 says that this can be done if the President is satisfied that it is necessary for him to take immediate action. The Constitution also says that ordinances must be approved by both the houses of the Parliament within 6 weeks of the Parliament reassembling, or they shall expire on their own. Ordinances also cease to operate if resolutions disapproving them are passed by both the houses. Now, the government also takes the ordinance route to address matters of public concern. For example, this was the case with the Criminal Law Amendment Ordinance 2013, which was issued in response to the protests around the 2012 Delhi gang rape incident. The ordinance was passed in February 2013 and was placed before the Parliament in March the same year. It became a law in April 2013. With regard to issuing ordinances, as in other matters, the President acts on the aid and advice of the Council of Ministers. And just as the President can issue ordinances under Article 123, the Governor can do the same under Article 213 when the State Legislative Assembly is not in session. The ordinance-making powers of the President and the Governor are broadly comparable. The only difference is that the Governor needs the President's permission to issue ordinances in 3 cases listed in Article 213. Now, ordinances are only temporary laws as they must be approved by the Parliament. But what if instead of placing the ordinance before the Parliament, the government instead lets an ordinance expire and then the President promulgates it again when the Parliament is not in session? Governments have done this before, and the Supreme Court has held that re-promulgation of ordinances is a fraud on the Constitution unless considered absolutely necessary or on very rare occasions. During the monsoon session this time, the Parliament will be looking at least 11 bills to replace the ordinances brought during the COVID-19 lockdown. These include several agriculture-related ordinances and an ordinance on the Insolvency and Bankruptcy Code. Can state governments give preferential treatment to certain subcastes within the scheduled castes? A larger constitution bench of the Supreme Court, that means one with 7 judges or more, is set to consider this and settle the debate once and for all. Essentially, a 5-judge bench has now ruled that preferential treatment can be given to certain scheduled castes over others to ensure equal representation of all scheduled castes. But this is the opposite of what another 5-judge bench had ruled back in 2004. The issue right now before the Supreme Court was the Punjab government's decision to give first preference to Balmikis and Mazhabi Sikhs for scheduled caste reservations in the government jobs in the state. Now, the major question involved is whether the state governments actually have the power to do so, that is, to provide for such a subclassification. This is because the Constitution under Articles 341, 342 and 342A empowers the President to notify those castes and tribes that will be called scheduled castes, scheduled tribes and socially and educationally backward classes. Clause 2 of all these 3 provisions says that the Parliament can make a law to include or exclude any caste or tribe from this list. So the question that would now be considered by the larger bench is whether subclassification amounts to excluding some castes from these presidential lists, which is a step that only the Parliament can take through a law and not the state government. The debate on subclassification has also brought the concept of creamy layer back into focus. Essentially, those arguing in favor of subclassification have said that in substance, it's only an application of the principle of creamy layer. As to what is the creamy layer, the landmark Indra Sawhney judgment had first ruled back in 1992 that backward classes can further be classified into more backward and less backward classes. So those who fall in the creamy layer are considered ineligible for reservations. In a 2018 judgment, the Supreme Court had also upheld the creamy layer concept within the SCs and STs, but the central government has filed a review petition against the judgment and the case is currently pending. In several of the past KYC episodes, we have explained the concept of creamy layer in more detail, so I'll be linking those episodes in the description. In its latest judgment, the 5-judge bench also tried to justify subclassification, saying that the benefits of reservation are not trickling down to the weakest of the weak. It has therefore said that the state governments should be allowed to give preferential treatment to certain subcastes, of course based on a rational basis to ensure that they are adequately represented. But those arguing against the subclassification have asserted that special treatment is given to SCs due to the untouchability that they suffer. They have also submitted that the subclassification that the Indra Sawhney judgment allowed was only about socially and educationally backward classes, and that concept cannot be made applicable to SCs and STs because they're different from OBCs. The Arunachal Pradesh Assembly has resolved to tell the central government to include the state in the 6th schedule of the Constitution. It has also sought amendment of Article 371H to protect the rights of its indigenous population. So on KYC next, we told you about 6th schedule and Article 371H. Now the 6th schedule essentially has special provisions for administration of tribal areas in Assam, Meghalaya, Tripura and Mizoram according to Article 244 of the Constitution. And then these councils can make laws on matters like land, forests, etc. with approval from the governor, and can also assess and levy land revenue, taxes on land and buildings and tolls. So essentially, while in other states, the Legislative Assembly makes uniform laws for the entire state, these district and regional councils under the 6th schedule can make different regulations for their own regions. There are other perks as well. For instance, the matters on which the councils can make laws, if the state legislature also makes a law on the same matter, then the state law won't apply to the region unless the council issues a public notification directing this. The council can also apply the state law with exceptions or modifications. As for central laws or state laws on matters which are not under the council's exclusive domain, the governor has to issue a separate public notification to apply those laws to these regions with or without modifications. In comparison, the 5th schedule of the Constitution provides for administration and control of scheduled areas and scheduled tribes in a few other states. But the 6th schedule provides greater autonomy to the areas covered by it than the 5th schedule. For example, special bodies in the 5th schedule areas don't have the power to make laws, unlike the 6th schedule councils. So Arunachal Pradesh currently does not fall in either of the two schedules. It has demanded to be included in the 6th schedule to protect tribal rights of its indigenous population. As for Article 371H, it already provides certain special provisions for the state of Arunachal Pradesh. It says that the state's governor will have a special responsibility with respect to the law and order in the state. The governor can consult with the Council of Ministers and exercise his individual judgment on any action that needs to be taken with respect to the state's law and order. But the State Assembly has now demanded strengthening of these provisions to include several other safeguards. These include protection of religious or social practices of the tribes that are in the state, customary law and procedure of the state tribes, administration of civil and criminal justice involving decisions according to the customary law of the tribes, and ownership and transfer of land and its resources. This is Apoorva Mandhani for ThePrint. For more such videos, subscribe to our YouTube channel and follow us on Twitter, Instagram and Facebook.